morning, everyone. We are convening the Committee on Labor and Government Operations. It is Tuesday, January 30th, 2024 at 9:30 in Conference Room 309. We have a pretty good agenda today, but we'd like to keep it moving. In order to allow as many people to testify as possible, please try to keep your testimony to 2 minutes. If your 2 minutes runs up, I'm going to ask you to conclude your testimony and kind of wrap things up. Of course, you don't have to use the 2 minutes if you don't want. Because morning hearings must adjourn prior to the noon floor session, not all testifiers may have the opportunity to testify. In that event, please know that your written testimony will be considered by the committee. Please keep yourself muted. This is for anyone on Zoom. Please keep yourself muted and your video off while waiting to testify, and then again after your testimony is complete. The Zoom chat function will allow you to chat with the technical staff only, so if you're having technical issues, please let them know over chat. If you're disconnected unexpectedly over Zoom, you may attempt to rejoin the meeting. If disconnected while presenting testimony, you may be allowed to resume if time permits, but please note that the House is not responsible for any bad internet connection on the testifier's end. In the event of a network failure, it may be necessary to reschedule this hearing for decision making. In that case, an appropriate notice will be posted. Please avoid using any trademark or copyrighted images, of course. Please refrain from any profanity or uncivil behavior, as I will remove you from this committee. If a person testifies in person, please come up to speak into the microphone. Otherwise, the people on Zoom and online will not be able to hear you. Your microphone should be about a fist or a shaka away from your face. All right, first up on the agenda, we have HB 1638 relating to county labor standards. This authorizes the counties to adopt their own labor standards. Thank you. First up, we have the Hawaii Department of Labor and Industrial Relations in person with comments. Yeah, if you're in person again, please come up to the mic. Thank you.
Good morning, Chair Matayoshi, members of the committee. David Rodriguez with the Department of Labor and Industrial Relations. We stand on our written comments. Thank you.
Okay, thank you. Next up, we have PRP in person in support.
Aloha, Chair. Chris Delaney with Pacific Resource Partnership. Strong support of this measure. This is definitely an ongoing problem that we see throughout the counties. My testimony, I noted one, Miley Skycourt Hotels, labor violations. Another one on Kauai, a big one, S&A Industries. There's a bunch of labor violations. General Growth Properties, there was some in the past as well. So there's a lot of this unscrupulous contractors coming in and taking advantage of workers and so forth. And I think this will actually be a good compliance tool for the counties since they hold control over like permitting. They can also do labor standards to incentivize developers and contractors to actually promote living wages, state apprenticeship programs in order to make sure their members are well trained, et cetera. There's also ways of doing it using it as a stick if you're in violation of labor laws and so forth. Some municipalities throughout the nation, there's been a bunch, they actually use it to revoke permits, suspend permits, or not issue permits if there's violations in the last 3 to 5 years, so forth. So there's a lot of examples. I won't go into too many details, but I'm available for any questions later on, and we can talk a little more. Right? Thank you.
Next up, we have Hawaii Harbor Users Group in person with comments.
Aloha, I'm Melissa Pavlicek. I'm here today on behalf of the Hawaii Harbors Users Group. Our comments pertain to the challenges for multi-jurisdictional operations like harbors, and we requested some amendments. Thank you.
Okay, thank you. Next up, we have Hawaii Regional Council of Carpenters in support.
Chair and members, in strong support of the measure. I just wanted to maybe talk a little bit about S&A Industries. Basically, the feds found that this contractor in Kauai that did both jobs at the Hilton and Marriott resorts, they assessed them $693,000 for a scheme that deprived 110 workers in Hawaii for projects of overtime. So this is probably the most recent and most egregious of the violations. And what we're really looking for is just some sort of reporting and disclosure for large jobs that are economically significant, especially not just here on Oahu, but definitely on the neighbor islands, and allowing the counties to revoke or suspend and give permits to people who have been found to have violated and had no intention of following the law is really what we aim to do with this measure. And so we would just hope that we could get your committee's support to move the discussion forward, and if there's amendments that needs to be made, we're open to discussion. Thank you.
Okay, thank you. Next, we have Gabe Johnson, Maui County Council member, on Zoom in support. Is he on Zoom?
Hello,
Yep,
aloha,
go
chair
ahead.
members. My name is Axel Beers. I'm an executive assistant for Councilmember Johnson. Councilmember Johnson submitted written testimony in support, and I'd like to read the 3 reasons that he names in his written testimony. He strongly supports this measure because, 1, the Maui County Council by Resolution 22-203 approved for inclusion in the 2023 Maui County Council legislative package a proposed state bill to authorize counties to establish a county minimum wage higher than the state minimum wage by ordinance. And that was introduced as HB 111 and SB 230. Those are active right now. HB 1638 aligns with the intent of the legislation proposed in Maui County Resolution 22-203 by authorizing counties to adopt living wage standards. 2, appropriate minimum wage and living wage standards are best determined at a county level in correspondence with county needs because of county level variations and economic conditions. For example, the self-sufficiency budget for one adult determined in DBED's self-sufficiency income standard estimates for the state of Hawaii and County's 22 report varies by more than $10,000 per year between counties, a difference by as much as 25%. The United Way household survival budget varies for a single adult by as much as $14,100 per year between counties in Hawaii, or a difference of 37%. Authorizing counties to adopt living wage standards and other labor standards will allow these standards to better correspond to local conditions. And finally, counties are well positioned to enact changes in labor and wage standards. Because of the unique geography of Hawaii as an island chain state, low-wage earners from neighbor islands are especially discouraged from participating in the state legislative process due to the cost of travel, and they're thus limited in self-advocacy for better labor and wage standards. Allowing county-level decision-making on wage and labor standards would lower barriers to civic engagement on these issues, creating better governments. And relatedly, the state has not historically been responsive to living wage legislation or minimum wage increases. Since 1992, the state has enacted laws to increase the minimum wage only 5 times, and the current law has a final increase slated for January 1, 2028 to $18 per hour. But $18 per hour is not a livable wage right now for a single adult in Maui County. So for all these reasons and more, Councilmember Johnson strongly supports this legislation. Thank you.
Thank you. Is there anyone else here to testify in person or on Zoom on this measure? Yep. Operating engineers.
Hi, aloha, Chair, members of the committee. Pandey Miotonga III, Deputy Director of Politics for Operating Engineers, Local 3. I've submitted my written testimony for our organization in support. I just wanted to add that, coming from a compliance perspective and seeing a lot of cases that come through our unions where you have contractors who are stiffing their workers and not getting resolution for 2 years, 1 to 2 years down the road, where they're getting their money paid back because they've been stiffed for whatever reason, whether it's overtime, misclassification of their work. Allowing the counties to be able to add an extra tool so that we can go after these contractors who are doing those types of illegal things is what I think this bill has the potential to build. And so with that, I submit my testimony support. Thank you.
Thank you. And I should mention, I think one of the computers we had caught a computer virus, and we had all kinds of mess. So there might be some people who submitted testimony who are not on the testifier list. So if I don't call your name, speak up at the end of the bills, or at the end of your bill, so you can come up and testify. Okay? All right, anyone else here to testify on this measure? All right, if not, we will, any questions from the members? Okay, I've got a question for carpenters. So it seems you folks are the driving force behind this bill. The bill is interestingly worded, though. It seems to allow counties to set things like living wage, which does not seem to go to the heart of what you seem to be doing. It doesn't seem like you're trying to allow counties to set a living wage or minimum wage. It seems like you're trying to catch bad actors, which I'm not sure that has anything to do with a living wage. There's testimony in opposition that raises questions about the definition of the term labor standards. Can you clarify what exactly I'd like to narrow it down some.
You know, Chair, I think we'd be open to that. I think we've just been catching all of these various contractors that have been cheating and paying cash and getting not insignificant sized jobs. The one in Kauai was a $8 million hotel renovation. The one in Oahu was, I think, $10 million. So we're open to any revisions that you think would be necessary. Again, what we're trying to do is increase reporting and disclosure for these types of projects so that they can tell us who the workers are, they can tell us what the workers are getting paid, if they're getting paid benefits or not, like retirement, like medical, and then also whether if these workers, all of them are supposedly so-called independent contractors. Okay, well, if they're all independent contractors, do all of them have Hawaii licenses to operate general contracting businesses or contracting businesses in Hawaii? So I don't think the intent was to allow counties to set a minimum wage. I think that gets into a very murky territory. So we're sensitive to that. What we want to do is we want to see more reporting, more disclosure, and then also when we go and talk to the counties and say, hey, S&A Industries, by the way, is coming back and they were trying to get another job. And we're like, well, why are you guys giving them a building permit? Well, we have to. We can't not give them a building permit. And it's like, well, how do we stop these bad actors from getting building permits? They're like, well, we can't do that because we're preempted from doing that. And so that's what brought us here to the legislature, to kind of bring the matter in front of you guys and let the you and your esteemed colleagues kind of come up with something that is reasonable and kind of gets at these bad actors.
Okay, so it sounds like it's reporting standards and the ability to deny permits. That would seem to be what would take care of this issue that you're raising in your mind. Is that correct?
To me, that's reasonable without getting into this idea of like, oh, now the counties can start establishing their own minimum wages and family leave and all of that. That's something I think that is best left to the discretion of the state. But when you start getting into like these economically significant jobs, how do we make sure that there's some disclosure that goes along with the building permit, and then that the county does have the power to deny giving somebody a building permit if they've shown a record and established a history of violations?
Okay. Anything else to add?
Nope.
All right. PRP, do you have any thoughts on this, on the change?
We're supportive of the change, Chair. So, yeah, that works.
Okay.
Yeah. Thank you.
Thank you. Members, any other questions? Okay, let's move on to HB 1643, relating to indebtedness. We've got two testifiers today. First up, we have HGEA in support.
Good morning, Chair, Vice Chair, members of the committee. Nui Sabas with HGEA, standing on our written testimony and strong support. Thank you.
Okay, thank you. Next up, we have UPW in support.
Good morning, Chair Matayoshi, Vice Chair Garrett, members of the committee, Kamakana Kaimaloa, Government Affairs Manager, United Public Workers. We stand on our written testimony and strong support, and we'll be available for any questions. Thank you.
Thank you. Anyone else here to testify on this measure? Anyone on Zoom? Okay, members, any questions on this measure? Okay, I've got one for UPW. So the line that we're drawing is moving it way back, and I do have sympathy for those making not very much per paycheck, and we don't want to take away, we don't want to cut into their basic living expenses. That's absolutely not what we want to do. There are people making quite a bit more than that can afford a higher rate of deduction. At the rate of 5%, it would take a very long time for the state to recoup all of that, or $50 a week if the amount is quite large. So I'd like to draw at least one line, maybe two, to tier this to make it so that people making more money that can afford to pay it back and cut into more of their discretionary money instead of their required expenses can do so at a higher rate. Well, what do you think that is? In your testimony, you kind of threw out $1,500 a month, or I think $1,000 a month as one of the benchmarks. That might be a little too low for me. I was considering maybe $1,500, but I'd like to know your thoughts.
Sure. We would, our members are actually lower income earners. So for us, that benchmark is critical, obviously. I think we'd be amenable to that line in the sand. But, we would defer actually to HGA on sort of the higher income earners and how that has an impact on them.
Okay, but I want to know, for you guys, you are the lower income workers, so what do you think is a fair line per pay period that someone could pay, that they could start paying more than $50 a paycheck or more than 5% of the amount? I mean, where's the, your members, where's the more comfortable line, more reasonable line?
I think maybe 70, between the two. So between 50 and 100, so 75 in terms of per paycheck. Percentage wise, 25% is definitely.
Or what's the, sorry, not
just the
line,
actual.
How much would they need to make per pay period to bump them up a tier that they could start paying more per pay period? Because right now you'd like it down to 5% or $50, and that's fine for the lower income, under $1,000 kind of thing. But at what point does someone make enough that they can start paying more per pay period back, you think?
I think it would actually be around $1,500.
$1,500?
Yes.
Okay. And do you think it'd be reasonable for someone making maybe $2,500 a paycheck to pay a little bit more even?
I think so.
Gross, not net.
Gross. Okay. Yes.
Okay. Do you think HGA has an opinion? HGA, Nui, do you have an opinion on this too? And this isn't something that happens too often, right? I mean, this is not like every other person kind. So, what do you think?
Yeah, we would be open to exploring kind of a tier system depending on how much an employee earns. I don't have specifics right now, but we can work with you, Chair, and the members of this committee to work that out should this bill move forward.
Okay, I'll tell you what. I'm kind of inclined to more blanket. Why don't we work on it, and I'm going to put in 3 tiers, probably, but give it some thought, and maybe we can come back around to it.
Perfect. Thank you.
Members, any other questions? Okay, let's move on to HB 1673, related to workers' compensation. Got 2 testifiers. First up, we have DLIR in support.
Good morning. The DLIR stands on its written testimony in support. Thank you.
Okay, thank you. Next up, UPW in support.
Chair, Vice Chair members, Komakana Kamalo again for UPW. We represent most of the county workers that actually would fall within this category, or as defined as solid waste workers. So we're in strong support of this bill. Appreciate it.
Thank you. Anyone else here to testify on this measure? Okay. Members, any questions? All right. Seeing none, let's move on to HB 1686, related to insurance. This is the chiropractors bill. First up, we have DCCA with comments.
Good Good morning, Chair Matayoshi, Vice Chair Garrett, members of the committee, Gordon Ito, testifying on behalf of DCCA Insurance Division. We stand on a written testimony offering comments. I'll be glad to answer any questions.
All right, thank you. Next up, we have the Hawaii Insurers Council with comments.
Thank you, Chair. Good morning. Vice Chair, members of the committee, Allison Ueoka for Hawaii Insurers Council. I'm not going to read you my testimony, which offers some comments, but I did want to share with you a little bit of where we are in the personal insurance market. This is from a recent article in the Wall Street Journal. It says, for many Americans, getting insurance for both their cars and homes has gone from a routine, generally manageable expense to a do-or-die ordeal that can strain household budgets. Insurers are coming off some of their worst years in history. As losses mounted, inflation only made matters worse, boosting the cost of repairing or replacing cars or homes. Homeowners and drivers are facing sharply rising premiums, less coverage, and fewer, if any, choices of insurer. In some places, the only options are bare bones coverage or none at all. That can make homes worth less and harder to sell and cars less affordable. Thank you, Chair.
Okay, thank you. Next up, we have Turning Point Chiropractic on Zoom in support. Not present? Yeah, are they present in the room in person? You're Turning Point Chiropractic, yeah?
My name is Dean Shivers. I do own Turning Point Chiropractic, and I'm also the president of the Hawaii State Chiropractic Association.
Okay, you were going to be up eventually, so go ahead.
Yeah. 30 years ago, when these original laws were put into place, there were some bad actors in the chiropractic profession. Those chiropractors are all long gone. The insurance companies have enjoyed 30 years of a fixed price while the cost of living expenses has increased dramatically. And what we're asking for isn't a blank check, but it's tied to the Medicare fee schedule, the same bill that was passed a few years ago for acupuncturists. Hawaii has a shortage of doctors in general and chiropractic especially. This bill will help encourage more chiropractors to come and work in the islands. Thank you.
Thank you. Next up, we have American Property Casualty Insurance Association in opposition on Zoom. Oh, in person.
Aloha, Chair, Vice Chair, Annie Makapagal on behalf of American Property Casualty Insurers Association. We do respectfully oppose the measure as written, as echoing the sentiments of the Hawaii Insurers Council. Thank you.
Thank you. I believe the last person we have on my list is an individual, Dean Shivers, in support on Zoom. Not present? Oh, that was you. Okay, I'm sorry. Anyone else here to testify on this measure, in person or on Zoom? All right, members, any questions? You get your chance. All right, I've got a question for Hawaii Insurance, for Allison. So if the bill went into effect as is, what can you give us kind of a ballpark on what the effect would be on the auto insurance rate?
It's a percentage of the personal injury cost, so it just depends, but it's guaranteed to be a price increase. So medical care is a certain percentage of PIP, so it depends what you buy. The more coverage you buy, right, the less impact on the total premium. But for those who buy minimum limits coverage, right, that impact is going to be greater. So it's a percentage of personal injury protection coverage.
For minimum limits, because those are probably the people that are going to feel the impact the most. Can you give me just a ballpark of what the impact would be?
I cannot. It depends, because in the workers' compensation medical fee schedule, the way chiropractic charges have been allowed, it can be, the cost can be manipulated greatly, so they can treat different areas of the body. So sometimes costs can go as high as $200 a visit. So that, of course, would be almost 3 times what the reimbursement rate is today. So it just depends how it's being charged and whether it's going to be allowed or not.
Okay. Thank you. Members, any other questions? Yep. Vice Chair.
All right, Mr. Ueoka, could you come back, please? Sorry, just note in your get your steps in. You note in your testimony that this may have the unintended effect of resulting in a higher number of uninsured motorists on the road. Do you have
Right.
data as to the current number of uninsured motorists?
I think APCI pegs it around 10%, which is up a notch. We've been hovering at about 9% for several years, but it is edging up now. So I think that we're around 10%. I'm not sure what the national average is. It's probably around 14. So when we were at 9, national average was around 13. And we attribute that mostly to containing costs. The lower the product, the more people buy it.
Thank you.
Okay, any other questions, members? Okay, seeing none, we'll move on to HB 1637 relating to workers' compensation law. First up, we have DLIR in support.
Good morning. The DLR stands on its written testimony in support.
Okay, thank you. Next up, we have Hawaii Insurers Council with comments.
Good morning, Chair Madashi, Vice Chair Garrett, and members of the Committee on Labor and Government Operations. My name is Malia Leong, Vice President of Claims and Medical Management Services for Hawaii Employers Mutual Insurance Company. I am testifying today on behalf of Hawaii Insurers Council. Hawaii Insurers Council strongly supports the intent of the bill, which is to ensure the health insurers pay for the medical care if a workers' compensation claim is denied. This provision has been in the law since prepaid health care was enacted. Hawaii's Prepaid Health Care Act, which was enacted in 1974, was to provide widespread health insurance coverage to Hawaii's workforce. This broad and bold standard was ahead of its time by decades, as only recently the Obama administration enacted this type of coverage across the nation. We therefore believe that as a public policy, it is part of the broad mandate to health insurers to provide this coverage without charging the workers' compensation insurer for any fees if it is later accepted as a covered workers' comp claim. A 3% fee based on the amount paid by the health insurer is not reasonable and should be borne by the health insurer as part of its mandate to broadly cover workers. The section of the bill that allows an injured worker to get reimbursed for any out-of-pocket expenses, including co-pays, should be clarified that the provider must reimburse the injured worker. The workers' compensation insurer is prohibited from charging any co-payments to the injured worker and is further restricted from reimbursing providers more than the law allows. Finally, the requirement that the employer's investigation is completed within 30 days is not realistic and may not be possible due to reasons outside the control of the insurer. For example, if the injured worker refuses to sign a medical release, the claim cannot be properly investigated, and the insurer should not be punished for actions outside their control. Other reasons include availability of independent medical evaluations and subpoenas. We ask that this bill be amended to remove the 30-day investigation period, remove the 3% penalty, and clarify that the health insurer must reimburse the injured worker for out-of-pocket expenses. Thank you for the opportunity to testify today.
Thank you. Next up, we have American Property Casualty Insurers Association with comments.
Aloha, Chair, Vice Chair. Basically, we are supporting the measure, but we would like clarifying amendments, specifically as to it similarly echoes the sentiments of the Hawaii Insurers Council, but we would further like to specify that to ensure that the workers' compensation insurer and employer is only liable to reimburse reasonable and necessary medical expenses as related to the covered injury. Thank you.
Thank you. That's all the testifiers we have listed. Anyone else here to testify on this measure? Fair?
I apologize for not sending in my testimony earlier, but
Blame
I
the
do have
virus.
a written one I can pass out.
Okay, thank you.
Good morning, Chairman and members. My name is Fairlene Noone. I am the Director for the Workers' Compensation and Third Party Liability Department for Premier Medical Group under the direction of Dr. Scott Miskovich. We are in support of HB 1637. I have worked in the legal field as a paralegal since 1992 and then started working for Premier Medical Group in 2015. During these 31 years, I have seen how much damage the delay in treatment can cost a patient. The current law that was passed, at its essence, was passed to help patients receive timely medical care, whether by a patient's private insurance carrier, while the insurance carrier exercises its right, the workers' comp insurance carrier exercises its right to investigate the liability of the employer or upon the acceptance of the workers' compensation carrier of the claim. These time limits to investigate can by request, be extended by the Department of Labor and Industrial Relations by and up to 60 days or more. In the meantime, patient's care is stalled. Following the patient's injury, it is a critical time for the medical provider to have set the course for treatment for the best possible outcomes. Such care would always start off to be conservative unless the injury is severe enough to warrant specialty care, at which point any delay in care could, and I have seen it happen, cause harm with the delay of the prognosis and appropriate care. Upon the billing, the private insurance carrier under HRS 386-21.1, the private insurance carrier has disregarded this request and replied with a denial, stating that this is a workers' compensation related. Then the bill remains unpaid. This happens so frequently that medical providers have decided not to treat workers' compensation patients, thus lowering the available medical providers to treat patients. Many of these medical providers are specialists, and these patients have been left looking out of state. For the patient, their lives have become difficult to live. Besides dealing with the physical pain, they would also deal with the financial pain. When the workers' comp carrier denies pending investigation, the patient is then forced to rely on TDI, temporary disability insurance, which is only 1/3 of a person's pay. This amount is not enough to survive on, not enough to pay for groceries, feed themselves and their family.
I'm sorry, Farah, that's been 2 minutes. If you could start wrapping up your testimony.
Yeah. In passing the bill, this would ensure the necessary coverage to see that these patients would be timely and effectively treated, allowing patients' care to progress and assist in the recovery and return the patient back to work as quickly and medically as possible. Ensuring payment would also give medical providers the confidence to treat patients knowing that they will be appropriately compensated. We are in support of HB 1637.
Thank you. Anyone else here to testify on this measure? Members, any questions? Yeah, I've got one for Malia. I know you have a problem with the 30 days. There's a number kind of thrown in there because that was, I believe, the amount of time before they needed to ask for an extension. Well, what do you think would be a more reasonable time on average? I mean, we want to cut out, we're really trying to focus on the outliers here. So on average, when a case kind of goes past the 30-day mark, is there kind of a bell curve where we could draw it at?
Well, since today I'm testifying on behalf of Hawaii Insurance Council, I think that it would be best to take that back to the other members, the other work comp carriers, to have a discussion. Because initially we have the 30 days, but we have up to that request for extension. It could be 120. And that is assuming that there's compliance, right? So if there's things that are out of our control, you know, and we're not having compliance with an injured worker or their legal representative, then we would be eligible for additional extensions. So it would be really hard to box that in, but I'm willing to take that back for further discussion.
So when you ask for an extension after the 30 days, is there a point where you start getting pushback when the extensions get too far? Is there some kind of,
yes.
What point is that?
Well, the Department of Labor is the gatekeeper, right, in terms of your extension request. So when you send it in after the 30 days, there has to be merit for your request for extension, right? And if they find that there is no merit to that, they can deny your request for extension, but of course then the employer carrier has the right to request a hearing.
Okay, and are the extensions granted in time period chunks, like every 30, 60 days you have to do another request?
Yeah, I mean, historically what I find is that the director will, depending on what the rationale is for your extension request, they might, if the request comes in for 120, they can say we'll give you 90 or we'll give you 60. So it really depends. I mean, as an example would be if we have a totally non-compliant injured worker, so we can't get records, we can't get anything. It's really hard to make a determination on compensability if we don't have that information available to us.
Is 120 days kind of a standard request, extension request?
I would say between 90 and 120
And that's 90 after the initial 30?
after the 30. I mean, ideally, the intent is to get the information within 30 days, but it's not always possible.
Okay, thank you. Joanne, you have any thoughts? Okay. All right, members, any other questions? Okay, if not, let's move on. Next up we have HB 1811 relating to the Department of Law Enforcement. First up we have Department of Corrections and Rehabilitation in opposition.
Thank you, Chair Matioshi, Vice Chair Garrett. I'm Tommy Johnson, the Director of the Department of Corrections and Rehabilitation. I know you have a long agenda, so I'll just summarize my testimony. We oppose this measure and we request it to be deferred. The redesignation, the creation of the Department of Law Enforcement created one umbrella for all the law enforcement agencies to be under, and it would provide better services. Nothing is taken away from the Sheriff's Division being rolled up into the DLE. Their long history goes with them. The DLE kept the 7-point star for the Sheriff's badge. They also kept the designation of First Deputy, the Sheriff, First Deputy, and Deputy Director. So I'd ask you to read our testimony closely. I think this is a bill looking for a problem that doesn't exist, and therefore we request it to be deferred. Thank you.
Okay, thank you. Next up, Department of Law Enforcement in opposition.
Good morning, Chair, Vice Chair, members of the committee. My name is Jared Radula. I am the Deputy Director for Law Enforcement with the State Department of Law Enforcement. This morning I'm going to summarize our testimony in 3 areas. We are in strong opposition of this bill. First, when the legislature acted to form the Department of Law Enforcement, it did so by directing 6 law enforcement units from different areas and combined them. The goal was to reinvent the way we do law enforcement in Hawaii. It's been decades in the making. We've only just gotten started about a month ago. However, we're already working hard to strengthen community safety, to improve forensic science, and we're working very hard to narrow the gap between our law enforcement officers' pay and that of the county police departments. Second, we recognize the importance of the history of the sheriff in Hawaii. In doing so, we've adopted the sheriff's uniform, their badge, their logo, and we've maintained the title of Deputy Sheriff and Sheriff Division in our organization. However, in recognizing the history of the sheriff, we also recognize the equally important heritage of the other 5 law enforcement units that were combined to form our department, including the Harbor Police with the Department of Transportation, investigators with the Department of the Attorney General, investigators with the Internal Affairs Office, the Narcotics Enforcement Division with the former Department of Public Safety, and the Office of Homeland Security with the Department of Defense. Indeed, these agencies have an equally important heritage. They can be traced back to early organized crime efforts to counter narcotics in the territory, and our collection of law enforcement and investigative information in the 9/11 era.
It's been 2 minutes. If you could start to wrap up your testimony,
Finally,
please.
the Department of Law Enforcement celebrates the diverse history and functions of all of the people in its ranks. That diversity makes us strong. This is why the name Department of Law Enforcement is best suited for our department. It recognizes our diverse history, function, and the people who work for us. Thank you for the opportunity to testify.
Thank you. Anyone else here to testify on this measure? Please.
Hello, Kakayaka. Chair Matayoshi and Vice Chair Garrett and esteemed committee members. My name is Sergeant Colin K. Malani. I'm also I was a Unit 4 shop steward, Unit 14 current shop steward now, and my colleague is with me today, and his name is Deputy Gary McElryan. I'm a current in-service member of the Sheriff Division for 42 years. I'm 65 years old. And the reason why I'm compelled to come here today and speak, and I will defer to my written testimony, is the fact that we express a very deep pride in knowing our history. And we date back, actually the title sheriff dates back to 992. And we've celebrated this. We had to do the same battle, I'm trying to limit this, the same battle 32 years ago when public safety was first formed under Act 211, under then Director George Sumner. And we fought to keep our name and our heritage alive. I was one of those individuals in that select committee, and likewise my colleague Gary McOryan. We're the final two. Gary is 68 years old, and we could have advocated for a lot of other issues like a retirement bill, a 25-year, but I'm not going to go there right now. In any case, I'm here to demonstrate the pride and the commitment of the rank and file. We make up almost 400 uniformed deputy sheriffs that the people see when they arrive here at our airports, and those that come off the docks on boats. With all due respect to my administrators, Deputy Director Gerald Redula and Deputy Director Mike Vincent, and our former administrator, Mr. Tommy Johnson. I've been here for basically 3 transitions. We were formerly under the Attorney General's office in 1975, and my older brother who passed away, Harold Malani, was a deputy sheriff for the Attorney General's office.
It's been 2 minutes, if you could start to conclude.
In any case, we voted on a patch, and this clearly was one that all the rank and file had agreed to. Now, if you look at our esteemed administrators, they're wearing a separate designation, and we've been advocating for one leader, one uniform, one badge, one clear line of authority. We are deputy sheriffs, and preaching a separate patch as this one here, investigations, state of Hawaii, and then to tie it in, we're the only ones with a history dating back to 1846. These are self-created. So we're looking for the pride, and we're looking for uniformity. We're not looking for divisibility and separability. We're looking to advance within our ranks, and we could also work in conjunction with the various 5 components of law enforcement. So we just ask your indulgence and support of our bill, 1811. Thank you, sir. And I would defer to any extra questions. We do have a 4-minute presentation on Jump Drive if anyone's interested in seeing it.
Thank you.
Thank you.
Did you want to testify too? Yes. Okay, please. Let's try to keep it to 2 minutes, though.
Sure. Good morning, Mr. Chairman Matayoshi, Vice Chairman Garrett. My name is Gary McOryan. I am currently a deputy sheriff. I have been a deputy sheriff for 38 and a half years, hopefully going to 39. The reason I support this bill is because back in the early 90s, when Department of Public Safety was created, they split the organization to have the corrections and the law enforcement end. Then the director, whose name is not necessarily need to be brought up, took the position that they were going to eliminate our titles as deputy sheriffs. And that was done. It was eliminated. We felt it was not the right thing to do, so we came to the legislature in 1992, introduced legislation, got it passed by both houses of the legislature. They went to the governor. The governor vetoed the bill. However, administratively, he gave us the titles back. So hence, we continue to be deputy sheriffs from then. Today, I agree with Deputy Director Redula's comments in terms of the consolidation, and we do not want to overlook the contributions of all the other law enforcement entities in the state, DLNR, harbors, what have you. That's not our issue. Our issue is that 85% of the men and women who serve in law enforcement at the state level are basically titled deputy sheriffs. So we do not see a problem in that these entities come into the Department of State Sheriffs, that they all are deputy sheriffs, but they can maintain their divisions, DLNR, Harbor's division. But we believe the title deputy sheriff is important because of the historical value created by King Kamehameha III in 1846. And in the modern day sheriff's department, we have stepped forward on the state level to provide law enforcement commitments to the community, beginning with, and I know I have 2 minutes. We've served with the Asian banking after the WTO fiasco on the mainland in Seattle. We took charge of that. When 9/11 occurred, because Governor Cayetano had placed the deputy sheriffs to be the primary law enforcement at the ports of entry, primarily International Airport. When 9/11 occurred, within 10 hours, deputy sheriffs were there providing security, and it continued for almost 4 months, 24/7. Then we go on and we look at the contributions of the sheriffs.
Sorry, it's been more than 2 minutes. If you have
we look
any
forward
last
to
statement.
meeting with the individuals to discuss further our position. But I stand in support of this.
Thank you. Any other individuals here to testify for this measure or on Zoom? Members, any questions? Yep. Go ahead, Rep. Capella.
I think it's for Department of Law Enforcement.
You're probably not close enough to the mic. Yeah.
It's heavy. How difficult would it be to put everyone under the same banner of deputy sheriff, even within these different, basically, I want to call them different departments, but different sections?
Yeah, right now, ma'am, there are different units within our department that hold different personnel classifications. And so there would be quite a complicated and in-depth discussion that would have to occur in order to sort of level everything out and to have everyone assume those kinds of one title like that.
Okay. Okay, thank you.
Thank you, ma'am.
Rep. Cabela, do you want or not?
Sure. I'm curious about this bill and kind of like its genesis. It just seems interesting to me.
The bill would not, it's cost effective. It would not even cost anything. All we're saying is that, and not taking away from their services and the prides of the different organizations, like you said, the different divisions. If we come under the Department of State Sheriffs, yeah, the change would not be as difficult as you might assume, because already some of the people who are wanting to come in, investigators from Attorney General's office, there's complications there in that they're not civil service employees. They're, this is my term, contractual employees who want to come into Unit 14, get the pay scale step level at Unit 14, but not want to hold the title of a sheriff investigator. They simply want to be investigators.
Okay.
Okay.
Thank
so
you.
There's a lot of stuff involved. Thank you.
Any other questions?
Thank you, Chair.
Okay, if not, let's move on to HB 1943, relating to health insurance. We've got a bunch of testifiers. I just want to make sure we get all through in time. Not for this bill, but for the remaining bills. 1943, HGA in support.
For the record, Nui Sabas with HGA, standing on a written testimony and strong support. Thank you.
Okay, thank you. That's all the testifiers for this bill. Anyone else here to testify? UPW.
Chair, I apologize. We did submit testimony, but we do stand in support of this bill. Thank you.
Thank you. Anyone else here to testify? Members, any questions? Okay, let's move on to HB 2198, relating to public employment. This is to allow negotiation of retirement benefits. First up, we have ERS in opposition.
Good morning, Chair, Vice Chair, members of the committee. I'm Tom Williams, the Executive Director of the Employees Retirement System, and I am here to testify in opposition to this particular measure. We believe that subjecting our retirement plan to the uncertainties of collective bargaining by individual units places the long-term sustainability of our plan at risk from both a legal as well as a fiscal perspective. Currently, retirement benefits are exempt from negotiation. Current statutes also preclude any benefit enhancement until our plan is 100% fully funded. We're at 62.2% funded and have an existing $13.7 billion liability. Trust law and Internal Revenue Service regulations govern the operation of our plan. We think that this bill would violate our fiduciary responsibilities under trust law and place our tax exemption at risk. We think that negotiation of these retirement benefits, the cost of which won't be known for years, if not decades, negotiating those things today would be a mistake, allowing those to be negotiated. We've submitted this bill to outside tax counsel, and they agree with our assessment. Thank you for the opportunity to testify, and I'm available for questions.
Okay, thank you. Next up, we have HGEA in support.
For the record, Nui Sabas with HGEA, standing on a written testimony and strong support.
Next up, we have Department of Budget and Finance in opposition.
Chair members, Neil here for Department of Budget and Finance. The department stands in strong opposition to this. As Mr. Morrison said, the state has started to make progress to bring to address the unfunded liability situation. Our testimony shows that, we will go backwards with this and we'll become in an unsustainable situation. And trying to implement this in terms of administration of the plan with all these different benefit levels is going to be a nightmare. And then the whole process with binding arbitrations and the acceptance and the legislative approval of that is going to be very problematic too.
Thank you. Lastly, we have UPW in support.
Chair, again, Kamakana Kaimula, UPW. This is just an attempt for us to have a larger conversation about the retention of our employees. I think a lot of the focus in terms of filling vacancies has been on recruitment rather than retention. I think there has been an effort over the last several years by Maui County to restore retirement benefits for police officers. We think that this does not conflict with Section 88-99, the moratorium that Mr. Williams had alluded to earlier, because collective bargaining actually would take precedence. This is not providing actual retirement benefit enhancements, but merely the opportunity to negotiate them during collective bargaining. So we stand in strong support. Thank you.
Okay, thank you. Anyone else here to testify on this measure? Members, questions? Yep, Vice Chair.
Mr. Williams, please. Thank you for your testimony. I note in your testimony that you do mention that the accrued liability is $13.71 billion, and the funded ratio is 62.2%, as you noted. When are we projected to hit that 100% fully funded mark?
Thank you for the question. We're projected to achieve 100% full funding in the year 2046, 23 years from today.
Okay, I wasn't around in 2011 when this moratorium was put into effect. Were you with ERS at the time?
No, I was not.
Okay, but I assume you're familiar with some of the background.
Yes, I am.
Okay, and I think this is tied to the downturn in the economy, 2008. Stock markets took a nosedive, and the state was trying to get some certainty to help rebuild the value of the ERS. Is that correct?
In part. I think it was more related to the unfunded liability. The downturn in the economy exacerbated the unfunded liability. And what we realized that under the then current contribution levels, our liabilities would never be fully funded. They would go on in perpetuity. So there was a change in 2012 to reform the plan, to change the benefits, to increase the contributions. And that was the primary reason for the changes in 2012. The economy exacerbated, but it showed that the plan was unsustainable absent these reforms.
Okay, thank you. And then you note again in your testimony that you're pretty certain that you said this does violate the moratorium in 8899. But in your testimony, you reflect that it may violate. So since you've submitted this, you have a different opinion. You're much more certain in that stance?
Oh, absolutely. we were, I guess, somewhat passive in saying it may, but absolutely we believe it would violate the benefit enhancement prohibition.
Okay, thank you. Thank you, Chair.
Thank you. Any other questions, members? Okay, sorry, I have one more for you, Tom.
Yes, sir.
So we talked about violating 89-11. I'm concerned too about you in your testimony you raised that this might violate IRS codes. Is that a certainty again, or is that it might if the negotiations go a certain way?
I think it's quite a certainty, sir. There are prohibitions in IRS rules for cash or deferred options in the context of public employee retirement plans. And I believe the definition of what we're talking about here is negotiation between current compensation and some level of deferred benefits. I think that negotiation of retirement benefits would constitute a violation of that provision. But there are other provisions related to definitely determinable benefits when individuals are employed. I think to the extent that these benefits could be negotiated on a periodic basis, it might violate that. There are non-discrimination rules, there are plan document rules. There are a number of rules that we think that this would violate IRS requirements.
And what would be
and then we would lose our tax qualification,
Okay.
which would be disastrous.
So the effect
for
would be that we're jeopardizing our tax qualification.
Absolutely.
Okay.
Absolutely.
Okay, thank you.
Thank you, sir.
Anyone, members, any other questions? If not, we will move on to HB 2552, relating to employee benefits. First up, we only have one testifier, DLIR, in support.
Law, the DLIR stands on its written testimony in support. Thank you.
Thank you. Any other testifiers here for this measure? Members, any questions? All right, let's move on to HB 2575, relating to construction workforce development. First up, DOE, with comments.
Hello, Chair Matsuyoshi, Vice Chair Garrett, and members of the committee. Winston Sakurai, Curriculum Innovation Branch Director, testifying on behalf of the Department of Education. The department stands on its written testimony with comments. Thank you for the opportunity.
Okay, thank you. Next up, DLIR, with comments.
Aloha, the DLIR stands on its comments with concerns. Thank you.
Thank you. PRP, up next, in support.
Aloha, Chair Chris Delaney with Pacific Resource Partnership. We stand on our written testimony and support. Thank you.
Anyone else here to testify on this measure? Members, any questions? Vice Chair.
Department of Education, please. Hi there, thank you for being here. I note in your testimony that you said there's currently 37 out of 45 high schools that offer this in some form. Do you
Yes.
have data as to like how many students that covers or the uptake percentage?
We do not, but we can get that for you.
Okay, thank you. Thank you, Chair.
Members, any other questions? Is Castle High School one of them?
Great question.
And if they are, okay, good. I do have a question for DOE and actually DLIR too, if DLIR could come up as well. So this bill would place this program in DLIR. It seems more appropriate to be placed in DOE, although DOE's testimony was that there is something, I mean, your program is sort of already in effect. Would you say that your program more or less encompasses the goals of this bill already?
Correct.
Okay. And DLIR, would you think that it would be more appropriate in DOE or in DLIR for this program?
Thank you for posing that question, Chair. So we feel that really it's difficult for us to effectuate this with the current program because we can't be the lead where we're building things at DOE. So really it's more appropriate to be with the Department of Education.
Okay, just DOE then. You can have a seat. Thank you. Because you already have a program in place that seems to at least go to the intent of this new program, are there pieces of this new program that you would like to see implemented to expand your program or to improve it?
You know, one of the things that we're always looking at is workforce development data, and we try to follow the trends that are happening in the community. And so part of it is additional support is always necessary. We do try to provide, especially for small schools, is really a need across not just Oahu, which has a lot of support, but our neighbor island schools.
Is there any part of this bill that would give you a power or an ability or resources that you do not currently have that you want?
I think we actually have a lot of flexibility that's given already to the legislature to enact a lot of these things. So we've been trying to do our best to serve the local population and the school communities.
So in your opinion, this bill is duplicative of the powers and resources that you currently have?
Yeah, we already have some opportunities that we can continue to expand upon within the department, so correct.
Okay, PRP? Kind of a similar question. Because it seems like DOE already has a program that roughly does the same thing, do you think that the DOE program is currently inadequate and that's why you folks are pushing for one in DLIR?
Oh, well, Chair, we were just supporting the intent of this bill, and basically we have a lot of projects coming up in the near term, and we want to make sure that our local residents are prepared in our schools and ready to build the projects we need to build more affordable housing, renewable energy projects, et cetera. And this is a great opportunity. We want to see people coming in, taking the work and leaving, right? We want our local residents to benefit from this. In terms of what's out there, I'm not sure. I haven't been a part of the discussions, but we're just supporting the intent and in strong support of our building our local workforce. Thank you.
I agree. Thank you. Members, any other questions? Sorry, we're past that already. Thanks, sir. All right, moving on to HB 1556, relating to state employment. Oh, we do have a person. D. Hurd, in support.
Good morning, Chair, Vice Chair, members of the committee. My name is Brenna Hashimoto. I'm the Director of the Department of Human Resources Development. We're in strong support of this measure. We appreciate the legislature's recognition that we do need additional resources in order to meet the needs of the state departments to fill positions. So we're incredibly grateful for the support and urge you to pass this measure. I'm available for any specific questions you might have.
Okay, thank you. Anyone else here to testify on this measure? Okay, members, any questions? Okay, seeing none, we'll move on to HB 1611, relating to law enforcement officers. First up, we have the AG's office with comments on Zoom, but many people have been showing up in person.
Good morning, Chair Madayoshi, Vice Chair Garrett, members of the committee, Deputy Attorney General Adrian Daco on behalf of the department. I'd like to emphasize 2 points in the testimony. This bill seems very inconsistent in the regards of there's no objection to keeping track of misconduct, no objection to keeping track of domestic violence, no objection to keeping track of the National Decertification Index. On the other hand, you're giving officers a free pass to smoke weed or possess cannabis. That seems very inconsistent in that regard. And with regards to getting a conviction for a detrimental third, that's any defense attorney worth their weight in salt will cut that off at the pass before the officer is even convicted. You have a conditional discharge. You could get a violation expunged from your record. You could get a deferred acceptance of their no contents or guilty plea. So the officer will never get convicted, and it doesn't really address the underlying drug use issue. Secondly, there's language about you get a free pass for a substantially similar drug-related offense. Unlawful use of drug paraphernalia is also a violation under 329.43.5. That statute makes no distinction between cannabis paraphernalia, cocaine paraphernalia, crystal meth paraphernalia. So I'll leave you with this. An officer could be convicted of possessing a crystal methamphetamine pipe and get a pass. And that doesn't seem to be consistent with the kind of message or standards we want to hold our law enforcement officers to. Thank you for the opportunity. I'll be available to answer questions.
Thank you. Next up, Department of Law Enforcement in opposition.
Good morning, Chair Matayoshi, Vice Chair Garrett, members of the committee. The Department of Law Enforcement opposes the measure. Same two reasons. We have no problem. We want our officers to be, of the highest moral standards and conduct. We have no problem with the idea of holding them to that. Our concern is the Law Enforcement Standards Board may not be ready to implement this by the time the bill is enacted. So we don't want to be in a situation where we can't hire somebody because the Standards Board hasn't had a chance to act. So that's the first part. I think that's probably something that can be rectified. The second one, and Mr. Dakwa, covered, the substantially similar, problems, the concerns, and the agencies need to have the discretion to look at the officers that are coming to them for jobs. When you put on a badge, the public expects the best. The agencies need to look at, okay, was this somebody in their younger days kind of did something stupid, and all of us do stupid things when we're young, but is this somebody who recently was engaging in conduct that's going to call into question their ability to make good law enforcement related decisions? And so for those reasons, we ask that the bill be heard or dismissed or held, please. Thank you.
Next up, we have Office of the Public Defender in support.
Good morning. I'm Ben Lowenthal from the Office of the Public Defender. We are in support of this bill. As we stated in our written testimony, it is a sensible tool that we believe will help any employer, and that would include law enforcement officers. We do believe that in our experience, or in my experience, coming from Maui, as we have law enforcement agencies are facing a shortage or are aggressively recruiting people, this is a tool that is much needed. So I would actually join in the non-objection, so to speak, or in the need for a tool like this. We believe it's very important as we recruit law enforcement officers. So we support the bill in full. Thank you.
Thank you. Honolulu Police Department in opposition. Should be by Zoom. Not present? Anyone present? Okay. Anyone else here to testify in person or on Zoom on this measure? Okay, hearing none. Members, any questions? Yep. Rep. Kabala.
Office of the Public Defender. I just have a quick question. We're one of the only states that doesn't have a tool like this.
That is correct. Yes.
Is there's some opposition, but in your in your words, how could this be a benefit and possibly a cost saver to our state? Have there been police officers who have been hired in our state that have maybe been fired from other states?
We don't really know. There's no way to track it. And so that's why this is the first step for that. It's to have that kind of tracking, that kind of data available. One of the reasons why we say it's costly is because even if a lawsuit against a county is filed against a police officer in the course of their duties, even if it's not successful, it's still very costly to the county, to the state, in having to handle these kinds of lawsuits. So if this is cut off at the pass with some sort of data, or at least the first step towards collecting this data, that's how it would save the state money.
Perfect. Thank you.
Thank you.
Thank you, Chair.
Members, any other questions? I've got one. Department of Law Enforcement. In your testimony, you stated that July 1st, 2024 was might be too soon an implementation date. What is a reason? I don't want to push this thing too far, but what's a reasonable implementation date for you folks?
Well, I think it's tied to the Standards Board. I don't know how quick they can act. If there's something outside of that the agencies can do separate and outside of the Standards Board, that might be something different. And I don't know enough about the Standards Board, but it's kind of tied to them. And we don't have a problem with, the accountability side. We agree. We want the best officers we can get. But I don't know when would be a good time to start implementing this because of the standards. Because the way the bill is written, you can't badge and gun somebody unless they meet the standards. Mm-hmm. And those standards have to come from the Standards Board. That's the dilemma that we've got. And
okay. I I have a feeling this bill will move through this committee in some form.
Yes.
Your testimony has noted that July 1st, 2024 seems to be too soon an implementation date. When this bill, or if this bill is heard by another committee, please have a date at that time.
Yes, sir.
Thank you.
Thank you.
Members, any other questions? Okay. Hearing none, we'll move on. HB 1639 relating to the Hawaii Employer Union Health Benefit Trust Fund Base Composite Monthly Contribution. What a fun bill name. We have one testifier, EUTF.
Good morning, Chair, Vice Chair, members of the committee. I'm Derek Mizuno, ETF Administrator. The ETF Board is in strong support of this bill. We stand on our written testimony, although I wanted to correct a typo at the beginning of the second page. The 2024 should be 2023. Thank you.
Anyone else here to testify on this measure? Members, any questions? Sorry, Derek, where was the typo?
At the beginning of the second page at the top, 2024 should be 2023.
2024 should be.
Yeah, and that's when we found out.
Oh, your testimony. Oh, I thought you meant there was an error in the bill.
Oh, no, no, in my testimony. Yeah.
That's fine then.
Okay.
Okay, thanks. That's something we didn't catch. All right, no other questions by members. We'll move on to HB 1640 relating to collective bargaining. First up, we have Department of Human Resource Development in opposition.
Brenna Hashimoto, Director of DHERD. We're in strong opposition to this measure. It would jeopardize our ability to maintain equitable pay, an equitable pay system and pay relationships between classes by allowing the unions to demand repricing of classes at any point in time. Currently, the statute allows them to negotiate repricing during our collective bargaining negotiations over the master agreement, and we believe that that process should remain. It's fundamental to the civil service system that we have equal pay for equal work, and that we have a systematic method of classifying and compensating positions. So to put this in the hands of individual arbitrators for particular classes would be very disruptive to our operations and jeopardize our ability to defend discrimination complaints against the state. So we're in strong opposition to this measure. Thank you.
Okay, thank you. Next up, we have HGEA in support.
Nui Sabas with HGEA, standing on a written testimony in strong support. I just want to add the state has roughly a 30% vacancy rate. One of the reasons why is due to low and uncompetitive pay compared to the private and federal sector. We are seeing reduction in services from our community. So we do believe that this measure, should it pass, will provide more competitive pay to jobs that aren't competitive. Thank you.
Thank you. Next up, City and County of Honolulu, Department of Human Resources in opposition.
Good morning, Chair Matayoshi, Vice Chair Garrett, members of the committee. I'm Nola Miyazaki, Director of Human Resources for the City and County of Honolulu. We stand in, with our written testimony, respectful opposition to this bill. I'm happy to answer any questions.
Thank you. Next up, we have UPW in support.
Kamakana Kaimaloa, UPW, stand on a written testimony in strong support. Thank you.
Thank you. Anyone else here to testify in this measure? Please. Budget and Finance?
Budget and Finance, we submitted testimony. I think it may have been late, but we have concerns with this bill, serious concerns with the bill.
Are they there? Oh, we do have it. Okay.
Thank
you. Do you have anything to add, or is that okay? Thank you. All right. Anyone else here to testify in this measure? Members, any questions? I've got a couple on this bill. Deherd up first. So is there a situation where repricing is needed? When do you think this tool is, why do you think this tool is here?
So repricing, well, pricing in general has to do with the salary range assignment that's related to a particular class of work. So in the civil service world, every class title, say Secretary 2, has a salary range assignment, say SR, I think it's 14 if I'm not mistaken. And so that relationship, that salary range assignment, ensures that there's parity across classes of work in the same bargaining unit. So we look, and that's based on the statute, we look, we do a study across similarly situated classes. If we were to just go and say, oh, we decide to make the secretary series, 2 pay ranges higher, then that throws things out of sequence. We need to maintain parity. So there are very few times where we find that things need to be repriced, and that usually has to do with there's been some change to the work itself. We recognize that jobs evolve and change over time, but it doesn't happen very often. And I think the situations that the unions are trying to pursue repricing are actually not repricing, but they should be addressed through things like shortage. If we find that there are particular market conditions that are affecting wages that are making us not competitive, then we have other mechanisms to address those kinds of things, like flexible hiring rates, like shortage, but repricing is not the appropriate tool for those kinds of situations.
Okay. And what's the effect of an impasse?
So it goes to an arbitrator. In this case, so the statute already allows the union to pursue repricing when they negotiate the master agreement. So that's once every 2 or 4 years. And they want to, through this measure, they want to be able to pursue repricing at any point in time for any class of work. So we simply don't have the resources, the staff, in order to do those studies. Basically, it would be on demand. We have only 30 days to initiate negotiations and then 90 days to render a decision. That's simply not feasible for the staffing level that we have. And we believe it should remain in sequence of when we're negotiating the master agreement.
Okay, so the impasse would force it into arbitration and an arbitrator would make a determination.
Correct, on that individual class of work or series of jobs that they're pursuing.
Okay, but if the arbitrator determines that the classification is wrong, then it should be reclassified, right?
It's not the classification, it's the pricing of that job.
I'm sorry, the pricing.
Right.
If they determine the pricing is wrong, then, I guess, isn't that the whole reason that this repricing tool is here and the impasse provision is there to allow this thing to move forward? What we've been hearing is that as it currently stands for repricing, DHERD is just able to say no and then effectively void this repricing tool. That's kind of the complaint. I do hear your complaint too, that we don't want a contract to close and repricing to immediately occur. That's fair. Maybe there should be some kind of delay between when a contract closes because everything was freshly negotiated and when repricing could start to occur. But it seems like this repricing tool is there for a reason and it's not being permitted to be used, I guess.
So we do have, I do have two comments related to that. So we do a repricing study every 4 years. So the unions, even in addition to the going to impasse through the master agreement, we do take recommendations for repricing once every 4 years. That's sort of the natural cycle under the statute. And so they have other opportunities to have us look at repricing. And secondly, if you put it in the hands of individual arbitrators who don't have any interest in maintaining equity across bargaining units, then we run the risk of having discrimination complaints and unequal pay between classes in the same bargaining unit.
Okay. UPW and HGA, I want you guys to respond, but up to you on who goes first. Why don't we take HGA first?
First, I'd like to respond to the shortage differentials that DHERD has pointed out. DHERD has provided shortage differentials for years. If they're going to keep providing shortage differentials, they may as well just reprice the position. I also want to add that, like I mentioned before, position pay within the state, within the counties, is extremely uncompetitive. For example, engineers in the state, they start off at making around $52,000 a year. The same engineer who just graduated college can go work at the shipyard, and I believe what we've heard starts at $75,000 a year. It's severe underpayment that has led to the state to result in such a high vacancy rate. Kind of switching topics and lists in regards to DHERD's response for an arbitrator. We can work with DHERD to develop a list of arbitrators that we can both agree on that is kind of, I guess, specialized, I guess, in employment pay or things like that. But yeah.
So if there's a repricing study done by DHERD every 4 years and you folks renegotiate your contract every 2 to 4 years and there are constant shortages, why at that time have the salaries for engineers or you name it, why hasn't this problem been dealt with in collective bargaining negotiations?
So usually during open master contract negotiations, we have so many job classifications. For bargaining unit 13, I believe we have thousands and stuff. I mean, obviously we prioritize certain job classifications, but unfortunately, sometimes, depending on the negotiation session, it just might not kind of make the cut. However, we can follow up with you to get more clarity on that part.
Okay, it just seems to me that we're dealing with this problem now as sort of a Band-Aid to when it should have been dealt with before. And if this really is a problem that's been, the shortages have been years and years, I'm not, and you intend to spend resources to try to reprice, I think there is some concern that you folks should have been doing this before, right? Too. So now you're asking for this other solution to undo part of a negotiated contract because you didn't deal with it at the time, and that's a little concerning because it's going to take more resources and time and arbitrators and so on and so forth when it should have been dealt with at the bargaining table, I think. But it sounds like that your argument is that there's too much going on. I'm not sure that's a good excuse.
Yep. Let me circle back with you on that. We need to check we'll get back to you with a better response.
Okay. UPW, did you have anything to add?
We'll defer to young Nui on this.
What power you wield. All right. Thank you.
Yeah, thank you.
Members, any other questions? Okay. Seeing none, we'll move on to our last bill on the agenda, HB 1641, relating to collective bargaining. Looks like we've got 3 on the agenda. HGA in support.
Nui Sebas with HGA, standing on our written testimony and strong support. Thank you.
Okay, next up we have Department of Budget and Finance in opposition.
The department is opposed to this measure basically because there's a possibility we'll create 15 different type of health plans, trying to administer that, trying to handle that in negotiations. And then the other problem with that is a lot of the unions, the final determination under this would be under binding arbitration. And binding arbitration, we reach a settlement, it's presented to you. It's an all or nothing deal. So, good with the bad, and then some things come in, you may have to reject the whole package because of that.
Okay, thank you. UPW, last up, in support.
Again, Kamakana Kaimaloa, UPW. We stand on our written testimony and strong support. Thank you.
Okay, thank you. Anyone else here to testify on this measure? Members, any questions? If not, we'll take a short recess for decision-making. Recess. Reconvening the Committee on Labor and Government Operations. It is still Tuesday, January 30th, 2024, in Conference Room 309, approximately 11:15 a.m. So we're meeting for decision-making. First up is HB 1638, relating to county labor standards. Chair's recommendation is to revise this, amend this bill to make it clear. We're going to be getting rid of the word labor standards, but making it clear that this bill deals with reporting and disclosure on wages, benefits, and employment status, and also gives the counties the ability to deny a building permit if a company has a history of violations. We're also going to exempt harbor-related operations and defect the date to July 1st, 3000. Members, any questions? All right, sorry, any comments? Okay, Vice Chair with the vote.
Okay, thank you, Chair. Members voting on House Bill 1638, Chair's recommendation is to pass with amendments. Chair and Vice Chair vote aye. Representative Capella?
Aye. Representative
Martinez? Aye. Representative Sayama is excused. Representative Tam?
Aye.
Representative Alcos? Chair, recommendation is adopted.
Okay, thank you, members. Next up, HB 1643, related to indebtedness. We are going to be revising this to create multiple tiers. For those with a gross wage in their pay period for $1,500 and below, it'll be what is in the bill, what is in the bill currently. For those between $1,500 and $2,500 gross, it will be $75 or 15% of salary and wages, and for $2,500 and above, it will go back to what was originally in the law. So $100 and 25%. We're also going to be defecting the date to July 1st, 3000. Members, any comments? If not, Vice Chair for the vote.
Okay, thank you, Chair. Members voting on House Bill 1643, the Chair's recommendation is to pass with amendments, noting the excused absence of Representative Sayama, who will be excused for the remainder of today's decision-making. Anyone voting nay? Or with reservations? Seeing none, Chair, your recommendation is adopted.
Thank you, members. Next up, HB 1673, relating to workers' compensation. This is for solid waste workers. Chair's recommendation is to simply defect the date to July 1st, 3000. Members, any comments? Okay, seeing none, Vice Chair for the vote.
Thank you, Chair. Members voting on House Bill 1673, Chair's recommendation is to pass with amendments. Anyone voting nay or with reservations? Seeing none, Chair, your recommendation is adopted.
Thank you, members. Next up, HB 1686, relating to insurance. This is the chiropractor's bill. We are going to be reverting the language back to the original law, but changing the $75 to $100 a visit. Members, any comments? Oh, and I'm sorry, defecting the date as well to 3000. Members, any comments? Okay, if not, Vice Chair for the vote.
Thank you, Chair. Members voting on House Bill 1686, Chair's recommendation is to pass with amendments. Anyone voting with reservations or nay? Seeing none, Chair, your recommendation is adopted.
Okay, thank you. Next up, HB 1637, relating to workers' compensation law. Chair's recommendation is to change the 30-day period to 90 days for when the penalty will apply. I will note that the 3% is put in was supposed to be kind of for more inflationary purposes, which I'll note in the committee report, although I'm not stuck on that number. We do want to make sure the bill reflects that the repayment would be directly to the insured worker, that the reimbursements will only apply to medical expenses related to the covered injury, and to defect the date to July 1st, 3000. Members, any comments? Oh, and technical amendments for clarity, consistency, and style. Members, any questions or comments? Okay, seeing none, Vice Chair for the vote.
Thank you, Chair. Members voting on House Bill 1637, Chair's recommendation is to pass with amendments. Anyone voting with reservations or nay? Seeing none, Chair, your recommendation is adopted.
Okay, thank you, members. Next up, HB 1811, relating to the Department of Law Enforcement. Chair's recommendation is to defer. Next up, HB 1943, relating to health insurance. Chair's recommendation is to simply defect the date to July 1st, 3000. Members, any comments? Okay, seeing none, Vice Chair for the vote.
Thank you, Chair. Members voting on House Bill 1943, Chair's recommendation is to pass with amendments. Anyone voting with reservations or nay? Seeing none, Chair, your recommendation is adopted.
Okay, thank you. Next up, HB 2198, relating to public employment. Chair's recommendation is to defer this bill. I have concerns that ERS brought up some pretty strong concerns about violating IRS codes that might jeopardize the whole thing. So we'll defer that, but I appreciate the discussion on this bill. Next up, HB 2552 relating to employment benefits. Chair's recommendation is to defect the date to July 1st, 3000 and add technical amendments for clarity, consistency, and style. Members, any comments? Okay, seeing none, Vice Chair for the vote.
Okay, thank you, Chair. Members voting on House Bill 2552. Chair's recommendation is to pass with amendments. Anyone voting with reservations or nay? Seeing none, Chair, your recommendation is adopted.
Thank you, members. Next up is HB 2575 relating to construction workforce development. This is clearly an area we need more workers in. Clearly, especially with Lahaina, we need more workers to rebuild. We need more skilled labor. I don't think that this is the right vehicle to do it. It sounds like DLIR is going to have a very difficult time coordinating with DOE. DOE already has a program more or less similar to this. More funding for the DOE program, I would be completely in favor of. I don't want to create a duplicative program that would be difficult for DLIR to administer when there's an existing one in DOE already. So I'm encouraging the introducer to look into more funding or expansion of the DOE program, but my Chair's recommendation is to defer this measure at this time. Moving on to HB 1556 relating to state employment. Chair's recommendation is to defect the date to July 1st, 3000. Any questions or any comments? If not, Vice Chair for the vote.
Thank you, Chair. Members voting on House Bill 1556. Chair's recommendation is to pass with amendments. Anyone voting with reservations or nay? Seeing none, Chair, your recommendation is adopted.
Okay, thank you, members. Next up, we have HB 1611 relating to law enforcement. Chair's recommendation is to delete the section relating to promoting a dangerous drug in the third degree and all related language. Defect the date to July 1st, 3000, but note in the committee report that the start date may need to be later than the original date stated in the bill. And also note that the Department of Law Enforcement is looking into that. We're also going to, on page 4, line 9, we are changing the reference to International Association of Directors of Law Enforcement to its full name, International Association of Directors of Law Enforcement Standards and Training. Members, any questions or comments? Okay, seeing none, Vice Chair for the vote.
Thank you, Chair. Members voting on House Bill 1611. Chair's recommendation is to pass with amendments. Anyone voting with reservations or nay? Seeing none, Chair, your recommendation is adopted.
Okay, thank you. Okay, next up, we have HB 1639 relating to Hawaii Employer Union Health Benefits Trust Fund Base Composite Monthly Contribution. Chair's recommendation is to move this along, defecting the date to July 1st, 3000. Members, any comments? Okay, seeing none, Vice Chair for the vote.
Thank you, Chair. Members voting on House Bill 1639. Chair's recommendation is to pass with amendments. Anyone voting with reservations or nay? Seeing none, Chair, your recommendation is adopted.
Okay, thank you, members. Next up is HB 1640 related to collective bargaining. Chair's recommendation is to insert a provision that the impasse cannot trigger within 180 days after a contract goes into effect, and to defect the date to July 1st, 3000. Members, any comments? Okay, Chair has one comment. As we stated in our testimony, this does seem to be an issue. We definitely need to be more competitive with the private sector. I think, though, that the mechanism that needs to be used is collective bargaining. I think that the unions do need to, at the table, try to fight for those positions where they feel are underpriced and frankly are underpriced, and have been getting more compensation through shortages and other methods as well. So this is a more costly, repricing is a more costly method that involves arbitrators and all kinds of things that we don't want to pay for. So I'm hoping that this bill will not be needed too much in the future. Members, any other comments? Okay, hearing none, Vice Chair for the vote.
Thank you, Chair. Members voting on House Bill 1640. Chair's recommendation is to pass with amendments. Anyone voting with reservations or nay? Seeing none, Chair, your recommendation is adopted.
Yeah, thank you, members. Last up, we have HB 1641 related to collective bargaining. I see some issues with this bill, especially in the discrepancy between that it could create between employees. There is another bill that we passed just now that would require parity between the public and private sectors, which would vastly increase the amount across the board that the employers would have to pay, that the state would have to pay for EUTF benefits. That, I think, is the more consistent approach that deals with some of the complaints that DEER has about violating certain laws. So at this time, I'm going to recommend deferring this bill. Okay. Thank you, members. We are adjourned.